This lecture provides an overview of tort law, as well as negligence and strict liability, in which intent is not an element. Part of doing business is the risk of being involved in a lawsuit. An ever-increasing business operating cost is the premium to obtain liability insurance to pay an adverse judgment in a suit. Many of these suits involve torts. In fact, in the United States today, negligence is the dominant cause of action for accidental injuries. For those who suffer harm, tort law provides a remedy for acts causing physical injury or interfering with physical security and freedom of movement, for acts causing destruction or damage to property, and for the invasion of protected interests in such things as personal privacy, family relations, reputation, and dignity. As new interests develop with social change, new torts are recognized to protect those interests. This lecture includes a look at strict liability law, in which intent is not an element. Strict liability is an important cause of action on which product liability is based. The items that you will learn in this lecture include stating the purpose of tort law and how torts differ from crimes. You'll identify the types of intentional torts and name the elements of negligence. Also, we'll understand strict liability and the circumstances in which it can be applied. Most crimes involve torts, but the commission of a tort is not always a crime. A crime is an act so reprehensible that it is considered to be a wrong against society as a whole. The state prosecutes criminals who may receive jail terms, fines, or both. A tort action is a civil action of which one person brings a suit of a personal nature against another. The state is not a party, and the judgment may impose damages but no jail term. The purpose of tort law is to provide an injured party with a remedy. The tort law system has been criticized as encouraging unfounded lawsuits, excessive damages, and costly consequences. At the federal level, the Class Action Fairness Act of 2005 shifted jurisdiction over cases involving large numbers of plaintiffs and large amounts of potential awards to the federal courts. At the state level, about half of the states have limited damages or banned punitive damages, especially in medical malpractice cases. Tort reform isn't one single idea or law. Instead, it's a group of ideas and laws designed to change the way our civil justice system works. A successful defense absolves the defendant from full or partial liability for damages. Apart from proof that there was no breach of duty, there are three principal defenses to tortious liability: consent and warning. Typically, a victim cannot hold another liable if the victim has implicitly or explicitly consented to engage in a risky activity. This is frequently summarized by the maxim volente non fit injuria, Latin meaning to a willing person no injury is done, or no injury is done to a person who consents. In many cases, those engaging in risky activities will be asked to sign a waiver releasing another party from liability. For example, spectators to certain sports are assumed to accept a risk of injury, such as a hockey puck or baseball striking a member of the audience. Warnings by the defendant may also provide a defense, depending upon the jurisdiction and the circumstances. There is also comparative or contributory negligence. If the victim has contributed to causing their own harm through negligent or irresponsible actions, the damages may be reduced or eliminated. The English case in Butterfield v. Forrester back in 1809 established this defense. In England, this contributory negligence became a partial defense, but in the United States, any fault by the victim completely eliminated any damages. That meant that if the plaintiff was 1% at fault, the victim could lose the entire lawsuit. This was viewed as unnecessarily harsh and therefore amended to a comparative negligence systems in many of the states. As of 2007, contributory negligence exists in only a few states, such as North Carolina and Maryland. In comparative negligence, the victim's damages are reduced according to the degree of fault. Comparative negligence has been criticized as allowing a plaintiff who is recklessly 95% negligent to recover 9% of the damages from a defendant. If the claimant is involved in wrongdoing at the time the alleged negligence occurred, this may extinguish or reduce the defendant's liability. The legal maxim, extirpe causa non oritur, or in Latin, the American wording is no right of action arises from a despicable cause. Thus, if a burglar is verbally challenged by the property owner and sustains injury when jumping from a second-story window to escape apprehension, there is no cause of action against the property owner, even though that injury would not have been sustained but for the property owner's intervention. In contrast to U.S. courts, courts in Europe generally limit damages to compensatory damages. Punitive damages are virtually unheard of in European countries. Even when plaintiffs do win compensatory damages, they generally receive much less than would be awarded in a similar case brought in the United States. In part, this is because citizens of European countries usually receive governmental provided health care and relatively generous Social Security benefits. Another reason, though, is that European courts tend to view the duty of care and the concept of risk differently than U.S. courts do. In the United States, if a swimmer falls off a high diving board and is injured, a court may decide that the pool owner should be held liable, given that such a fall is a foreseeable risk. If punitive damages are awarded, they could total millions of dollars. In a similar situation in Europe, a court might hold that the plaintiff, not the pool owner, was responsible for the injury. Tort laws in other nations also differ in the way damages are calculated. For example, under Swiss law and Turkish law, a court is permitted to reduce the amount of damages if an award of full damages would cause undue hardship for the party who was found negligent. In the United States, the courts normally do not even take a party's economic circumstances into consideration. An intentional, unexcused threat of immediate harmful or offensive contact is an assault. Words or acts that create in another person a reasonable apprehension or fear of harmful contact is an assault. The interest protected is freedom from having to expect harmful or offensive contact. A battery is an unexcused, harmful, or offensive physical contact intentionally performed. The interest protected is the right to personal security and safety. The contact can be to any part of the body or anything attached to it, including an automobile in which one is sitting, and can be made by some force the defendant sets in motion. False imprisonment is the intentional confinement or restraint of another person without justification. The interest protected is the freedom to move without restraint. Confinement can be by physical barriers, physical restraint, or threats of physical force. Moral pressures or threats of future consequences are not sufficient. Business people are often subject to suits for false imprisonment after attempting to confine suspected shoplifters. Most states allow a merchant to detain a suspected shoplifter if there's a reasonable cause for suspicion and the confinement is reasonable. In some states, a merchant can use the defense of probable cause. Wrongfully hurting another's reputation is defamation. Doing so orally is slander. Doing it in writing or in a form of communication that has the potential harmful qualities characteristic of writing, such as pictures, signs, statutes, and films, is libel. To establish defamation requires proof of a false statement of fact. The statement must be about the plaintiff and tend to harm the plaintiff's reputation. Publication to one other than the one being defamed. And actual malice if the plaintiff is a public figure. The publication requirement is the defamation requires that the publication of the statement, that is, that it be communicated to someone other than the defamed party. Defenses include the truth. Other defenses, privileged communication as a defense, a privilege, for example, statements made by judges during a trial may be qualified or conditional. Public figures, it's a defense to lack actual malice, knowledge of falsity, or reckless disregard for the truth in making statements to the press about public figures. Here's an interesting case. The New York Times versus Sullivan is one of the significant libel cases. This case grew out of an advertisement placed in the New York Times in 1960 to raise money for civil rights causes. Titled, "Heed Their Rising Voices," the ad stated that thousands of African American students were engaging in nonviolent demonstrations in affirmation of their right to live in dignity. The ad claimed that the students' efforts to uphold the guarantees of the Constitution and the Bill of Rights were being met by an unprecedented wave of terror by those who would deny those guarantees. The ad described a number of events by way of illustration, including the expulsion of students for demonstrating at the Alabama State Capitol in Montgomery, and the truckloads of police armed with shotguns and tear gas that rang out in the Alabama State College campus. No specific public official was named. The ad asked for funds to support the student movement, the struggle for the right to vote, and the legal defense of Martin Luther King, who had been indicted for perjury. The ad was signed with the names of 64 well-known personalities in public affairs, religion, trade unions, and the arts. L.B. Sullivan, commissioner of the Montgomery Police Department, claimed that he was implicitly the butt of alleged libelous charges. In fact, the ad was full of mistakes unrelated to the alleged libel. So, for example, the students hadn't even been expelled for demonstrating at the Capitol, but for demanding service at a lunch counter in the Montgomery County Courthouse. Citing the unrelated mistakes, Sullivan's former employee testified that he would not reemploy Sullivan if he believed the things that the paper said he did. Under Alabama law, the statements were found libelous per se on the ground that they injured Sullivan in his reputation, profession, trade, or business, and the jury awarded him $500,000. The Alabama Supreme Court affirmed the decision. The Times appealed. The United States Supreme Court reversed the decision. The Supreme Court ruled that even applications of the law of libel must be made against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Only proof of convincing clarity that a false and defamatory statement concerning an identifiable official was made with actual malice could constitutionally justify an award of damages for defamation of official conduct. The court pointed out that erroneous statements are inevitable in free debate and must be protected if freedom of expression is to have the breathing space that it needs to survive. Invasion of the right to privacy. 4 different acts qualify as tortious invasions of privacy. These are the use of a person's name or picture or other likeness for commercial purposes without permission, the intrusion into an individual's affair or seclusion, which is invading someone's home, illegally searching someone's belonging, eavesdropping by wiretap, unauthorized scanning of a bank account, compulsory blood testing, window peeping. Third, the publication of information that places a person in a false light. And last, the public disclosure of private facts about an individual that an ordinary person would find objectionable. Fraudulent misrepresentation may be a misrepresentation of facts or conditions with knowledge that they are false or with reckless disregard for the truth. There may be an intent to induce another to rely on the misrepresentation, a justifiable reliance on the misrepresentation by the deceived party, injury suffered as a result of this reliance, and a causal connection between the misrepresentation and the injury. Persons have a right not to be sued in the absence of a legally just and proper reason. Torts related to abusive litigation includes malicious prosecution, which is suing out of malice without probable cause, and abusive process, using a legal process in an improper manner, or to accomplish a purpose for which it is not designed. The latter does not require proof of malice or a loss in a prior legal proceeding. Business torts include wrongful interference with a contractual relationship, wrongful interference with a business relationship, and wrongfully entering into business. Any lawful contract can be the basis for this action. The plaintiff must prove that the defendant actually induced the breach of a contractual relationship, however, not merely that the defendant reaped the benefits of a broken relationship. The elements are a valid enforceable contract between two parties, a third party's knowledge of the contract, the third party's intentionally causing either of the two parties to break the contract. Individuals may not interfere unreasonably with another's business to gain a share of the market. The distinction between competition and predatory behavior often depends on whether a business is attempting to attract customers in general or to solicit only those customers who have shown an interest in a similar product or service of a specific competitor. Bona fide competitive behavior is a privileged interference even if it results in the breaking of a contract. The public policy that favors free competition in advertising outweighs the instability that competitive activity might cause in contractual relations. A wrong against property is a wrong against the individual who has legally recognized rights with regard to the property. The law recognizes property as real property, land and things permanently attached, and personal property, things that are movable. Harm to land is not required. Trespass to land occurs when a person without permission enters onto the land, causes anything or anyone to enter onto the land, remains on the land, or permits anything to remain on it. A trespasser is liable for property damage. A property owner may be liable for injuries to the trespasser under a reasonable duty of care, which would mean to post warning signs or the attractive nuisance doctrine. But a trespasser can be removed by reasonable force. The trespass defense can be that the trespass was warranted, as when one enters to help another in danger. Then the so-called owner did not have rights of the property would be another defense for this potential tort. When an individual unlawfully harms another's personal property or otherwise interferes with the owner's rights to exclusive possession and enjoyment, trespass to personal property occurs. The tort may entail acts of damage, dispossession, or both. A defense exists if the trespass was warranted. When a person wrongfully possesses or uses the personal property of another as if it were theirs, conversion occurs. Conversion is trespass to personal property, more serious in terms of duration and use. Unlawfully taking property is trespass. Unlawfully retaining it is conversion. Believing one is entitled to the property is not a defense. Thus, someone who buys stolen goods is guilty of conversion even if he or she did not know the goods were stolen. The owner can seek their return or damages. Disparagement of property occurs when economically injurious falsehoods are made about another's product or property. Slander of quality is where publication of false information on another's product, alleging it is not what the sellers claim, is slander of quality. Actual damages must be proved. Improper publication may be both slander of quality and defamation. When publication denies or casts doubts on another legal's ownership of property, and when this results in financial loss to the owner, slander of title may exist. This is usually done knowingly. This case involves WELCO Electronics, Inc. versus MORA. What is PayPal information and how can it be the subject of conversion? PayPal provides an intermediary account for online purchases. PayPal charges the seller a fee for its service. Customers fund their PayPal accounts through electronic transfers from their own financial institution, which would be from a checking account, via a debit card or credit card. Customers have the right to control the use of their account, information which can be used to withdraw funds from their bank account. Possession of the debit card, credit card, or PayPal account information is similar to the intangible property interest in a check. The wrongful debiting of funds from a customer's account would interfere with the customer's right to possess and use those funds and constitute conversion. Does the holding in this case mean that any transaction involving a credit card that leads to a dispute is subject to a case of action for conversion? No. The holding in this case does not mean that any transaction involving a credit card that leads to a dispute can be subject to a cause of action for conversion. In this case, the court held that the misappropriation of a credit card that occurred here constituted a theft and a conversion. Other transactions involving credit cards that can lead to disputes occur when people use credit cards to buy or pay for goods and services. Disputes may arise regarding the quality of the goods, any fault concerning the quality of the service, or the appropriateness of the charge. But a person's willing use of a credit card to pay for goods or services has no relationship to the circumstances in this case. Here, WELCO did not consent to its credit card or its information being used by or on behalf of MORA. This is not a simple failure to pay money owed, which of course would not constitute conversion, nor does it concern a simple overcharge, which also does not constitute conversion. Negligence. Under negligence theory, a tortfeasor neither wishes to bring about the consequences of an act nor believes that they will occur. The actor's conduct merely creates a risk of the consequences. Without a creation of a risk, there can be no negligence. Negligence requires proof of 4 elements: duty of care, breach of the duty, causation, the breach must have caused the injury or the harm, and damages, a legal, recognizable injury. Negligence involves the careless performance of a legally required duty or the failure to perform a legally required act. Courts consider the nature of the act, the manner in which it is performed, and the nature of the injury and determine whether a duty is breached. The reasonable person standard is the duty is measured by a standard of reasonableness. The measure is objective. How would a reasonable person act in the same circumstances? The answer defines the duty. A reasonable person would exercise reasonable care. the duty of landowners. Business firms that invite people onto their premises usually have a duty to exercise reasonable care to protect their business invitees against foreseeable risks that the owner knew or should have known about. Then the duty of professionals. An individual with knowledge, skill, or intelligence superior to that of an ordinary person has a higher standard of care, that which is reasonable in light of his capabilities. The injury requirement. Without an injury, which would be a loss, a harm, a wrong, or invasion of protected interest, there is nothing to recover. The purpose of damages is to compensate injured parties. To discourage grossly negligent behavior, punitive damages may be awarded. Many actions may cry out for redress, but not all give rise to proper lawsuits. As with the familiar basketball adage, no harm, no foul, was the watchword for gaining access to a courtroom. And harm means something specific, demonstrable, injury actually incurred. The injury requirement is an anchor in tort law and is a cornerstone condition of the right to appear in court. As the Supreme Court recently affirmed, Article 3 standing requires injury meaning harm of a sort, concrete, particularized, and actual. In Rudzinski versus BB, the risk of being hit by a fellow golfer swinging his club at high speed was an inherent and inescapable risk posed by golfing, and since the golfer voluntarily encountered this risk through participation in the sport, he assumed any harm flowing from his co-participants' attempts to strike the ball. Also in Sanchez versus Candia Woods golf links, getting hit with an errant golf ball was a risk inherent in the game of golf, which the golfer voluntarily assumed. Here are some other examples of assumption of risk. In Morabito versus MacArthur, a soccer player assumed risks of contact with another player during the course of playing an interscholastic game, precluding liability of opponent and his parents, as well as the school district and its Board of Education and personal injury action arising from players' collision with an opponent during the game. There was also a collision between a runner attempting to score and the catcher was ordinary risk of softball that was reasonably foreseeable. Then in Bell versus Dean, a skier's injury sustained in collision with snowboarder arose from the general risk of colliding with another skier or snowboarder, and thus, because skier assumed the risk of such a collision, the snowboarder owed no duty to protect the skier from such risk. Under the doctrine of strict liability, liability is imposed for reasons other than fault. For example, strict liability is applied to abnormally dangerous activities because of their extreme risk. Strict liability is also a theory applicable in product liability cases. Strict liability is a legal doctrine that makes a person or company responsible for their actions or products which cause damages regardless of any negligence or fault on their part. A plaintiff filing a personal injury lawsuit under a strict liability law does not need to show intentional or negligent conduct, only that the defendant's action triggered strict liability and that the plaintiff suffered a harm. Whether or not a tort action is considered strict liability and what damages are appropriate will depend on your state law. Here is an example of a situation where a company, Standard Business Company, Joe, a supervisor at Standard Business Company, is walking down the street minding his own business when suddenly Albert, a former Standard employee, attacks him. In the ensuing struggle, Albert stabs Joe several times, seriously injuring Joe. A police officer restrains and arrests Albert. Albert is subject to criminal prosecution by the state. Now, the question arises, can Albert also be subject to a civil lawsuit by Joe? Yes. Alberts committed the torts of assault and battery. Some torts, such as assault and battery, provide a basis for a criminal prosecution as well as for a civil action. How important is tort liability? Well, a business can be exposed to negligence liability in a wide variety of instances. Liability to business invitees is a clear example. A business that fails to warn invitees that its floor is slippery after a rainstorm or that a parking lot is icy after snow could be liable to an injured customer. Business owners can be liable for nearly any slip or fall or other injury that occurs on business premises. Even the hiring of employees can lead to negligence. For example, a business can be liable if it fails to do a criminal background check before hiring a person to supervise a child care center, when an investigation would have revealed that the person had previously been convicted of sexual assault. Failing to properly supervise or instruct employees can also lead to liability for a business. Professionals such as physicians, lawyers, engineers, and accountants have a duty to their clients to exercise the skills, knowledge, and intelligence they profess to have or the standards expected of their profession. Providing anything less to a client or patient is a special type of negligence called malpractice. Here's a checklist for minimizing business tort liability. First, constantly inspect the premises and look for areas where customers or employees might trip, slide, or fall. Take corrective action whenever you can find a problem. Train employees on the importance of periodic safety inspections and the procedures for reporting unsafe conditions. Third, routinely maintain all business equipment. Check with your liability insurance company for suggestions on improving the safety of your premises and operations. Make sure that your general liability policy will adequately cover the potential exposure of the business, and reassess your coverage annually. Review the background and qualifications of individuals you're considering hiring as employees or agents. Investigate and review all negligence claims promptly. Most claims can be settled at low cost without a filed lawsuit. Although there are more claims for breaches of contract than any other category of lawsuits, the dollar amount of damages awarded in tort actions is typically much higher than the awards in contract claims. Tort claims are also commonplace for many businesses. Torts are civil breaches committed against another in which the injured party can sue for damages. In personal injury cases, the injured party will attempt to receive compensation with the representation of a personal injury lawyer in order to recover from the damages incurred. Tort law decides whether a person should be held legally responsible for injury against another and what type of compensation the injured party is entitled to. There are 4 elements of tort law: duty, breach of duty, causation, and injury. In order to claim damages, there must be a breach in the duty of the defendant towards the plaintiff, which results in an injury. The 3 main types of torts are negligence, strict liability or product liability, and intentional torts. All tortious charges of intentional interference with people or property involve intent, which provides for a civil wrong, knowingly committed by the offender. This contrasts with torts of negligence, which results from lack of concern or responsibility on behalf of the offender. These damages are dealt with through civil litigation.